Thank you very much, everyone, and good afternoon. Very happy to be here, and once again, what a pleasure to be back in a conference center, being with you live, and yeah, welcome after lunch. I hope you had a good break and are ready to dive into the latest EU policy and regulatory initiatives. So today I've prepared a presentation, and I focused on 3 areas in particular. First of all, we will zoom in on the content moderation reform that's currently ongoing, and you've heard already about the platform regulation earlier in the morning. So we will look at the DSA, the Digital Services Act, but from the DNS level and how it's relevant for domain name registries and registrars. And the second important topic is, of course, the cybersecurity reform and the NIS2 directive. I'm sure many of you have heard about that as well. Again, another very important piece of legislation in the area of cybersecurity that is directly applicable to registries and has an impact also on registrars, so we will look into that as well. And finally, I will also zoom into a few or 2 proposals in the area of intellectual property rights protection, specifically in the geographical indications area. And so these are 2 new proposals that also have the direct impact on domain names. And so it will be, in a way, an early alert to all of you to engage as the negotiations on those files will start soon. And so without further ado, let's look into the Digital Services Act. So as you've heard quite a bit today already, as we focused on the platform bit of it, this is the latest reform in the area of tackling illegal content, so the content moderation and intermediary liability framework. And very quickly on its status, it was proposed by the European Commission 2 years ago, and actually at this moment we are in the process of the finalization of that law. So as you can see on my slides, the political agreement was just recently been reached and agreed between 3 institutions. And before, of course, it can become a final law, it still needs to be approved by the European Parliament and the EU member states. So on that, so there's still a bit time in terms of when this part of legislation will become applicable directly in the member states, but we are already on the finishing line. And most importantly, for DNS level, I would like to zoom in a few important bits of it. So first of all, importantly for DNS and importantly for registries and registrars is the fact that as contrary to the existing liability framework, the DSA confirms that registries and registrars can be considered intermediaries. And this is an important bit because it's basically confirms or reaffirms the notion that infrastructure level registries and registrars in principle have a role to play when it comes to tackling illegal content. And this is really a change from the existing liability framework, which does not state any of those principles. And there was, according to the legislators, also the legal gap in the status of registries and registrars when it comes to tackling illegal content. And but luckily, despite the fact that DNS level is directly in scope of the DSA, it's also important to understand that the legislators also actually foreseen the proportionality principle of it. So not all digital services, not all intermediaries are subject to the same level of obligations or the same level of responsibility for the illegal content that might be disseminated via their services. So when it comes to DNS level, it's just important to remember that it's obviously different from the application layer, and we've heard that today numerous times as well. But nevertheless, registries and registrars would need to comply with the minimum so-called due diligence obligations. And as you can see on my slides, it entails a few important important notions or important policy change, also for our sector, for domain name sector. So most importantly, when it comes to tackling illegal content, DSA foresees the notification from the judicial or administrative authority. So there is no obligation to proactively seek for illegal activity on the service, including DNS level. And then, since these judicial administrative authorities can approach registries and registrars, then there needs to be also a single point of contact. So meaning that it should be clear on the website, or clear when the authority tries to approach an intermediary service, that there is a clear single point of contact where the authority can do that. And the DSA also foresees that there should be clarity of terms of service, meaning that if intermediary is engaged in some sort of type of content moderation, or if some particular activity is considered to be against terms of service, then it should be also clearly stated in the terms of service. And finally, any activity that is so if it's targeted towards taking the action against illegal content, it should also be transparent. So this includes all digital services on the DSA, including registries and registrars, who will be obliged to regularly report on these activities, meaning how many domain names were blocked because of the judicial order, or suspended because of some activities with regards to the terms of service. So these are the few obligations to keep in mind on how they're impacted and how they're impacting domain name level. So what is another important part on the DSA is, of course, that it's the revision of the intermediary liability framework. So meaning that when a particular digital service can be held liable for the third-party misconduct using the service of that intermediary. And it's important to note here that despite the fact that DSA confirms that DNS level, or the domain name registries registrars, have a play-to role when it comes to tackling illegal content, they in principle can only benefit from the liability exemption if they fall under the existing categories that are already exempted from the liability. So according to the current legal framework, and that's also been will be reinforced by the DSA, there are 3 categories of services that can be exempt from liability if they perform a particular function. So this includes, for example, mere conduit intermediaries, so like ISPs, access providers. Then there's a caching for obvious reasons, because these are the intermediate copies of content that might get transmitted, and obviously the provider cannot be held liable for this. And third category is the hosting level. And although DSA, again, I have to repeat myself, confirms that registries, registrars are in scope, it does not provide a clear exemption for the DNS level, and that's unfortunately still unclear even after all the negotiations on the DSA. So it's still unclear which categories, first of all, domain name registries, registrars can fall under, and second of all, the legislator does not provide that clarity, and essentially this means that it's left for the national level and the court action. So it's also unclear to which extent the final text has also tackled this issue, since co-legislators, so the European Parliament and the Council of European Union, have called to give DNS level at least some recognition when it comes to the existing categories. And for at least to confirm that it's similar to access level, but we unfortunately we have to see how the political agreement actually approaches this. But most likely it will be decided on national level and specifically in courts. So this leaves a legal gap still there, although there are those due diligence obligations on registries and registrars. So now I have to also perhaps give a little bit of indicator how to prepare for the future. So as I've already said, DSA is at the moment being finalized, and DNS level is in scope. So most importantly for all the registries and registrars present, the first notion is be prepared for more authorities to potentially approach you as an intermediary. And I would like to also point out that DSA also establishes a new type of authority, which is the Digital Service Coordinator. These specific authorities under the DSA have also some minimum minimum powers to, in addition to the judicial administrative authorities on the national level, that, for example, digital service coordinators can require on-site inspection of any intermediary under DSA, or specifically, very interestingly, for domain name level, in certain cases, order the temporary restriction to the interface. So this is a very vague wording, but essentially this means a blocking order, and potentially it could also impact registry or registrars. So, so this is something to keep in mind when the law will be in force. And other advice is, of course, to revise policies, as the clarity of terms of service is one of the due diligence obligations. So this is also something that I think is advisable when the DSA becomes into force. And include transparency reporting as a good practice, and also as a due diligence obligation under DSA. And as I already said, unfortunately, there is the legal gap on the level of liability exemption, and that's unfortunately difficult to prepare for. But here we are. Unfortunately, DNS has not received enough recognition as a separate category of services that require such liability exemption. So now I would like to move on to the cybersecurity bits. So the NIS2 directive is also something that is, I think, should be on the radar of all registries and registrars specifically. And similarly to DSA, it's been also proposed in the end of 2020. And it revises the existing cybersecurity legislation, and specifically the NIS directive that's been in force for quite some years. And again, similarly to DSA, it's also approaching its finishing line, and the political agreement has actually been reached last week. So again, it similarly requires still the confirmation and the adoption by the European Parliament and the EU member states, but we can expect this to be finalized by the end of this year. And very important here to keep in mind that, of course, as different from DSA, NIS2 directive is a continuation of existing law that already confirms the essentiality of digital infrastructure for the functioning of the society. So TLD sector was already in scope under the current legislation, and NIS2 just reconfirms that and adds more services in its scope. But of course, for TLDs, it's just another confirmation that DNS continues to be essential and critical infrastructure. It also revises the minimum cybersecurity measures that these essential services within the critical infrastructure, including digital infrastructure sector, would have to take. And here again, as most CCTLDs, specifically if we talk about CCTLDs, are already in scope of the first directive. Here there's little surprises, except of course more cybersecurity measures are potentially added. And this includes, for example, the supply chain security. There's also an obligation to report incidents, cybersecurity incidents, and but another very important bit, and I think we also heard a little bit this morning about this, is the registration data accuracy obligation. This is a completely new and unprecedented bit of regulation in the sense, since it directly targets who is and its availability for access. And here, specifically, registrars are in scope for this registration data accuracy obligation. And so I would like to zoom in now specifically to the data accuracy obligation. In order to prepare for the future, it's important to understand that the so-called data accuracy obligation also potentially includes verification of registrant identity. And it's a controversial part, but it's been added in the course of the negotiations, since first Commission proposed a simple accuracy obligation to be decided by the member state, following the practices of existing practices within registries and registrars, but the negotiators have added the verification obligation. And there is also an important part about publishing all data that is related to legal entities. So to again make sure that WHOIS is available for so-called DNS abuse tackling purposes. And if the data is not public, because, for example, it is related to personal data of individuals, then that data needs to be made available to legitimate access seekers within 72 hours. So this is basically, in a nutshell, the data accuracy obligation that will be put on all TLDs that are active in the EU. So this includes both CCTLDs and GTLDs. And here is also important to note that NIS2 directive is a directive, so meaning that there's more leverage space and more flexibility on the member state level. So member states could, in transposing the NIS2 directive, to also give additional guidance to including also the data accuracy obligation. So there might be some leverage in terms of different member states approaching data accuracy differently. And that also includes the verification obligation. So probably in those member states where there is a functioning EID scheme, it will most likely be encouraged. For others, anything could be encouraged. So that's something important to keep in mind as going into the future. And this is, again, important bit of the legislation and something to closely follow, but also to closely follow within the member state implementation phase. And finally, I would like to also touch upon a little bit on the new initiatives that, as I already said before, pertain to the issue of intellectual property rights protection, and specifically in the area of geographical indications. So there's been recently 2 proposals in the area of protecting these geographical indications for the agricultural products specifically, and also for the craft products. And as you can see on the slides, these are the names of these 2 proposals. And of course, they are primarily aimed to make sure that these geographical indications are protected in the EU and and fairly recognized as intellectual property, specifically for the craft products that are not currently being protected. But what is important to note here is that DNS level is very specific in scope and for a very specific purpose. And specifically, it concerns CCTLDs established in the EU that would have to participate in the so-called domain name information and alert system. And it's very important here to note that it should be developed in collaboration with the European Union's Intellectual Property Office. And so the EU IPO is the one to establish such a system, but of course closely related to data submitted to EU IPO by CCTLDs. And in a nutshell, this would mean that every time when a geographical indication application is submitted, then the respective applicant should also be notified if such a geographically indication or trademark is registered also as a domain name. And it's also important here to note that despite this domain name alert and information system, which is more of a maybe a simple whois search system perhaps, but very importantly to note here is that the proposals go also a little bit further and actually would oblige like sort of a direct right for the revocation or transfer of a domain name in case the applicant has a legitimate interest. And it's interesting to understand how it's actually related to the already existing instruments and existing procedures and policies in place within CCTODs, specifically if we talk about CCTODs in this scenario, and specifically the alternative dispute resolution processes and that are already established. So it's unclear why such alert system is needed in the first place, but and also why specifically it's only been so directly inserted in a very specific GI proposal. So again, how to prepare for the future here is to, of course, keep in mind that these are just the proposals, so there's still time and place to potentially impact these and the negotiations on them. So I would, of course, advise to get in touch, well, first of all, of course, to read them and to understand the impact of that, but also to get in touch with your national governments and specifically to really try to explain that IP rights are already protected and already protected within domain name space, and of course, any dispute can be resolved in numerous ways, and is it really necessary to create such an alert system? So, and there's also, of course, a few gaps as well at the moment. It's not clear how this alert system should be established. It's also unclear, again, how it is aligned with the existing alternative dispute resolution procedures, and importantly, it's of course has the potential to be expanded to all trademarks registered in the EU. So with this, I would like to, well, first of all, of course, thank you for your attention, and I'm happy to take any questions or remarks that you have. And if you want to be kept up to date with the EU policy and regulatory initiatives, please do subscribe to our newsletters, including our EU policy update that you can do via our Centro website at centro.org. And once again, thank you for your attention, and I'm happy to take any questions.